There's a new case from the North Carolina Supreme Court that does a great job of explaining how governmental immunity, sovereign immunity, and public officer immunity works in the state. Let's go through the case together. So this is a case out of Fayetteville, North Carolina, Cumberland County. It's called the Estate of Gregory Graham versus Ashton Lambert, individual and official capacity, Fayetteville Police Department, and the city of Fayetteville. I think to start, let's walk through sort of the basic facts of this case. Officer Ashton Lambert was a new police officer with the Fayetteville Police Department, and he was on his first solo shift after completing his training. And like many police officers just coming out of training, going solo for the first time, he was on the night shift. So just before midnight on July 24th, 2018, Officer Lambert gets dispatched to a domestic dispute. And I don't know the details on what the call was about, but what we do know is that Officer Lambert himself says it wasn't an emergency call. He was the third unit responding to the scene, so he was coming as backup, not an emergency even by his own judgment. Because this was not an emergency call, it was just a call for service, Officer Lambert was not using his blue lights or his sirens while responding. He was speeding, but he was only going about 5 to 10 miles an hour over the speed limit, which, at least where I'm from, is pretty normal. But he was using his computer. As he was driving, he was touching his laptop there in his patrol car. As Officer Lambert is responding to this call, he's driving down a road in Fayetteville that is wide and flat and straight. There were no street lights, but the street was well lit by businesses on either side of the road. At the same time, the decedent Gregory Graham is crossing this same road. He's not crossing the crosswalk. As far as I can tell, there are no nearby crosswalks. And he was drunk. Without any evidence that he slowed down or swerved or otherwise saw Mr. Graham, Officer Lambert crashes into him and kills him. And that's what this case becomes about. Mr. Graham's estate files this lawsuit against Officer Lambert and the city of Fayetteville and the Fayetteville Police Department. Those defendants all moved to dismiss the case on the grounds that they are immune from civil liability. Trial court denies that motion, saying, nope, you're not immune. And that decision gets appealed to the Court of Appeals and then eventually to the Supreme Court, which sets the stage here for a discussion of sovereign immunity, governmental immunity, public officer immunity, which is really what the heart of this case has to teach us. So let's start with sort of a foundational question, which is, why do we have immunity at all? This is a very, very old legal tradition, something we've imported here in the United States from England, from our days when we were British subjects. And the concept is this: you can't sue the king. The king has sovereign power. He creates the court systems, and so therefore he's not subject to the court system because he is the ultimate authority. Now, in the United States, our legal tradition says that the people are the sovereign. They hold the sovereign power, and they vest that sovereign power in the states to exercise on their behalf. Just as you can't sue the king, you can't sue the state without its consent. Now, we need to put a giant asterisk next to what I just said, because in practice, there are a ton of situations in which you can sue the state, even without its consent. But we're not going to get into those. For today's purposes, you can't sue the king, you can't sue the state without its consent. Sovereign immunity only applies to sovereigns, entities that wield sovereign power. In the United States, we have a doctrine called the separate sovereigns doctrine, where we recognize two sovereigns over every American citizen. There's the federal government, which is a sovereign, the United States, and then there's the individual state governments are also considered separate sovereigns. So sovereign immunity, you can't sue the king, you can't sue the state, that only applies to the states themselves, to an individual state itself, or to the federal government. It doesn't apply to municipalities or counties, towns, villages, cities, that sort of thing, within a state. They're not sovereigns. They don't have sovereign immunity. But they do act on behalf of the state. And so our legal doctrine says that a portion of that sovereign immunity trickles down to the county level, to the city level, in the form of what we call governmental immunity. Governmental immunity only protects local governments, cities, towns, villages, counties, that sort of thing, when they are exercising a governmental function as opposed to what's called a proprietary function. Governmental functions, those are things that really only the government can do. So a police force. Really only a government can have a police force. Contrast that with the proprietary function, which are things that both governmental entities can do, but also non-governmental entities can do. So operating a parking deck downtown Winston-Salem, where my office is. Well, we have government-owned and government-run parking decks, but we also have privately owned and privately run parking decks. So the operation of a parking deck would be considered a proprietary function. Local governments, cities, counties, don't have immunity for proprietary functions, only governmental functions. States, on the other hand, the state of North Carolina, the state and its agencies, it has immunity for all types of its functions because it's a sovereign, so it's sovereign immunity. Since the state has sovereign immunity, it can only be sued with its consent. And the state of North Carolina has consented to being sued through what's called the State Tort Claims Act. There's a federal equivalent called the Federal Tort Claims Act, where the federal government consents to being sued. But in both situations, the state or the federal government is dictating the terms. They're saying, here's what you can sue us for, here's how you have to go about suing us, and here's as much as you can recover from us if you choose to sue us. So we're going to let you sue us, but really only on our terms. And that's the power of being the sovereign. You get to do that. You get to dictate those terms. For local governments, our statutes, our law provides that they can also waive their immunity through the purchase of liability insurance. So if you want to sue a city or a county, you are going to have to show that governmental immunity doesn't apply, either because the action in question was a proprietary function, so there is no immunity, or by showing that they've waived that immunity through the purchase of liability insurance. In this case, there's no question that Officer Lambert and the city of Fayetteville were performing a governmental function. So the estate, the plaintiff, is trying to get around that immunity by alleging that the city of Fayetteville had purchased liability insurance. So that's how you can sue a local government, by getting around governmental immunity. But what about suing an individual officer or an individual government employee? What are the rules for that? So what you see in a suit like this one is the officer is being sued in both his individual capacity and his official capacity. He's being sued in both. So what's the difference? Well, official capacity claims are becoming, honestly, somewhat meaningless. Our case law has said for a little while, and this case makes clear that when you name a government employee in their official capacity, that's just another way of naming the city. My prediction is that we're going to see naming employees in their official capacity basically fade away because it's meaningless. There's really no distinction anymore between suing a government and suing an employee in their official capacity. All you've done is list the government twice. Since official capacity claims are basically meaningless, we're left really with just individual capacity claims. When can you hold an individual employee individually liable for their conduct? While the state and local governments, they have sovereign and governmental immunity, and obviously an individual doesn't enjoy those, an individual employee may still have immunity through what's called public officer immunity. Now, I've always called this public official immunity. I've seen it both ways. This opinion from the Supreme Court only calls it public officer immunity. So that's how I'll be at least trying to refer to it, although I'll probably slip up. Now, this question isn't actually on appeal in this case. The plaintiff didn't bring that issue all the way up to the Supreme Court, and so it's abandoned, and the court really doesn't spend much time on it, but we'll spend time going through it anyway, just so this can be a comprehensive primer on how immunity works. Public officer immunity protects public officers. We'll talk about who is a public officer in a minute, but not public employees, from being sued individually when they are acting within the scope of their authority. Basically, if someone's a public officer and they're doing something that they're legally allowed to do as a public officer, they can't be sued for that, even if they do it negligently. If they're exercising some power that's lawfully vested with them, they're not doing it corruptly or maliciously, then public officer immunity is going to protect them. If you can show that they were acting outside of their authority in whatever they were doing, or if they were acting corruptly or maliciously, then the public officer immunity will not apply. It won't protect them. Practically speaking, that's not usually where we see the dispute, The dispute is usually whether or not this individual employee is a public officer at all to be entitled to immunity in the first place. This opinion doesn't tell us how we determine who is a public officer, because like I said, it doesn't really spend time evaluating it. But the Supreme Court has told us before in a case called Eisenhower v. Hutto, or v. Hutto, I don't know how to pronounce it. In Eisenhower, the Supreme Court recognized a test that the lower courts can use to distinguish between a public officer and a public employee. Here are the elements. The first is that it said a public office is a position created by the Constitution or by statutes, meaning the laws passed by our General Assembly. The other distinction is that a public official exercises a portion of the sovereign power. The third element is that a public official exercises discretion while public employees perform ministerial duties. All right, so let's walk through those. A position created by the Constitution or by statutes. What does this mean? So a police officer, that is a position that is recognized in our statutes. In the laws passed by the General Assembly, they talk about police officers. So it's a position created by statute. Whereas a gentleman that works for the Parks Department and mows the grass, really important work, not a position created by the Constitution, not a position created by a statute. So the second one would be a public official exercises a portion of the sovereign power, right? So a police officer is wielding sovereign power to punish, to arrest, things that only sovereigns can do. The guy cutting the grass at the ball field isn't exercising any sovereign power. And the third is that a public officer exercises discretion while a public employee performs ministerial duties. The court helps us understand what a discretionary act is. It says discretionary acts are those requiring personal deliberation, decision, and judgment, whereas ministerial duties, on the other hand, are absolute and involve merely the execution of a specific duty arising from fixed and designated facts. So you can see how an officer, a police officer, is going to have to exercise deliberation and decision and judgment, whereas a person that works for the Parks Department is going to just be performing a ministerial act to accomplish a goal based upon a given set of facts. So we've gone over how immunity works generally here in North Carolina, but what about this specific case? Well, the Supreme Court basically says, hey, Court of Appeals, you applied the wrong standard, and so we're not going to decide this issue. We're just going to send it back to you to decide using the right standard. So we don't really get a decision here from the Supreme Court as to whether or not the case gets to survive. They send it back to the Court of Appeals for further decision making. If the Court of Appeals concludes that there's sufficient facts that the city of Fayetteville waived liability insurance, then the case will proceed. If the Court of Appeals decides that there's no dispute that the city of Fayetteville did not purchase liability insurance, then the case will most likely be dismissed at that stage. This case does a great job of laying out the elements of immunity. I expect it to be a case that lawyers cite for many years when they're writing briefs about immunity. And I hope this video has been helpful in going through the case and explaining how those types of immunities work here in North Carolina. If you found this video helpful or interesting in any way, please let me know so I keep making them. And if there's anything I can do for you between now and the next time I see you, don't hesitate to reach out.